Now we consider real estate transactions. This video and the two videos that follow it will present a complete summary of the law dealing with real estate deals. This video is going to handle landlord-tenant, and the law of landlord-tenant is much more heavily tested on the essays than it is on the multi-state bar exam. On the MBE, you might see a couple of questions dealing with landlord-tenant law, maybe one or two more, maybe not even that many. But it's important to realize up front that landlord-tenant law contains a fair amount of the law of contracts as well as a fair amount of the law of real property. This material is straightforward and it isn't difficult. It's also tested ritualistically, very much the same way, over and over again. So, we've got parties to a contract, a landlord on the one hand and a tenant on the other hand. Both of these parties have got duties and they've both got rights. The tenant's primary duty is to pay rent, and the landlord will be content by and large should the tenant do that. But also, the tenant has got a secondary duty, which is to maintain the premises. The tenant doesn't have to take responsibility for doing major repairs, but ordinary day-to-day repairs are the tenant's responsibility. The landlord has got much heavier duties. First of all, the landlord obviously has to provide the premises, but beyond that, the landlord has got a duty to allow the tenant to have the quiet enjoyment of the premises. And many essay questions deal with just this relationship, the different and contrasting duties between the landlord and tenant. Ultimately, many essay questions will present a factual situation in which there are problems with the leasehold, and ultimately we have to determine whether or not the tenant is still liable for rent. So keep in mind up front that landlord-tenant law, number one, has a lot of contracts law in it, and number two, it's very focused on remedies. Here in landlord-tenant law, we're dealing with civil litigation. The plaintiff has to have a theory of liability and a prayer for relief, and the defendant may well have defenses in both of these areas. So once we acknowledge that we're really dealing with a hybrid of contracts and real property here, and when we also see that we're dealing with parties to a contract, we next see that there are a few different types of tenancies, and these are basically measured by time. We've got a tenancy for years or some other fixed term. That's a tenancy that will expire at the end of the term automatically. We compare that to a periodic tenancy. A periodic tenancy goes on indefinitely into the future. Either party typically will have the right, at least after a certain period of time, to terminate that agreement, but the termination of a periodic tenancy requires notice, and you'll see a fair number of practice questions for the MBE dealing with whether or not that notice was adequate. Similarly, on the essays, you can see issues about a tenant wishing to quit the premises and the question presented being whether or not the notice given by the tenant to the landlord was adequate. You'll also see occasional issues dealing with tenancies at will, at sufferance, and with holdover tenants. To my way of thinking, these are not very big issues. If you encounter them in practice, feel free to annotate your outline. But the nuts and bolts of this material really go to the essence of the relationship between the landlord and the tenant. A very heavily tested issue, both on the multi-state and on the essays, is the issue of an assignment versus a sublease. So we've got an existing landlord-tenant relationship. The tenant then either chooses to assign or to sublease his or her interest. And the difference between an assignment and a sublease is very simple. In an assignment, the tenant is conveying all of his or her interests. In a sublease, it is less than that. So in a sublease situation, the original tenant will expect to regain possession, and that is not the case with regard to an assignment. Now here, we deal with an issue of contract interpretation in the context of real estate. And that issue is how we interpret a rental or a lease agreement with regard to assignment and sublease. And the quick bottom line is we are going to interpret the document strictly against the landlord. So the landlord is going to have to spell out graphically the rules with regard to assignment and sublease. And if the landlord doesn't do it, the tenant is free to assign or sublease. And if the lease only restricts one of these, an assignment or a sublease. The one that is not restricted is something the tenant will be free to use. And you'll see that these issues are tested ritualistically. This material is not difficult. Also, remember that with regard to both an assignment and a sublease, the original tenant remains secondarily liable in the event that the second tenant fails to pay rent. Again, it's very straightforward and very simple. And to go into one somewhat deeper level of real property black-letter law, the actual reason why it is that tenant number one remains secondarily liable is because tenant number one remains in privity of contract with the landlord, not in privity of estate because we've got a new tenant actually occupying the property. But tenant number one remains in privity of contract with the landlord and thus remains secondarily liable. Now, it is possible for us to envision a situation in which tenant number one is off the hook altogether, but that requires a novation or some other express acknowledgement on the part of the landlord that the tenant is no longer on the hook. Otherwise, the tenant will remain secondarily liable. And it's a very straightforward, very simple way to analyze the relationship between the parties. Also, realize that where we have a valid assignment, tenant validly assigns his or her interest to another party, the landlord still has all the identical obligations, all the covenants that were made between the landlord and the first tenant apply to the second tenant as well. The biggest issue beyond assignment and sublease is the issue of the covenant of quiet enjoyment. As I indicated earlier in this recording, often we are presented with facts in which there's a problem with the tenancy. And the more serious the physical problems with the apartment or the home at issue, the less likely it is that the tenant is going to be able to pay rent. And you'll notice, both just now and earlier in this video, I didn't give you a black and white line. I basically indicated that there's sort of a continuum. And I think that's true. But we can certainly agree that to the extent that a tenant is physically excluded from the property, that tenant is no longer going to be obligated to pay rent. A physical, actual eviction justifies a non-payment in rent. But the more tricky issue is the constructive eviction. Sure, here the tenant actually has access to some or all of the leasehold, but the value and the usefulness of the leasehold has been drastically diminished as a result of some problems on the tenancy, physical problems with the premises. And ultimately, on an essay, you may be called to make a judgment. You need to raise the issue, you need to explain the rights and responsibilities of both parties, but ultimately, the tenant's not liable to pay rent if the premises are not habitable. Now, putting this issue just a little bit to the side, we can see another set of issues dealing with the physical condition of the premises. But here, we're not focusing on the landlord's breach of duty, but instead we're focusing on the tenant. And here, we deal again with issues of waste. And we've seen waste one time before during this series of substantive videos. And it was when we were considering life estates. And we saw then that a life tenant does not have the right to commit waste on the property. And here in landlord-tenant law, we see exactly the same law, very much under the same intellectual framework. It's all identical. And also the same types of waste apply, the same labels apply. Voluntary waste equals vandalism. It's where the tenant physically damages the property deliberately. Permissive waste is where the tenant fails to live up to the minimal requirements that are placed on tenants to do ordinary upkeep. So permissive waste is where the tenant allows the property to deteriorate to an unreasonable degree. And then ameliorative waste is the type of waste that occurs where a tenant will, quote unquote, improve the premises, but may do so in a way that the landlord doesn't approve of. So an ameliorative waste classically would result in no liability because the plaintiff's property would be improved. But modernly we see increasingly tenants can be held liable for ameliorative waste and can be expected to return the premises to the condition that it was in at the time the tenancy began. And that leads us briefly to consider the issue of fixtures. A commercial tenant typically will attach heavy equipment to a leasehold, and that equipment will still be considered personal property. Still, in all types of landlord-tenant relationships, there can come a time where a tenant will make improvements on the property that are so substantial that they would be considered affixed to the property permanently. Under those circumstances, a tenant would not be allowed to remove those improvements because they would not be considered the personal property of the tenant. Probably the best example, a classic example of the sort of improvement that a tenant is allowed to carry away would be a window air conditioner. Yes, it's mounted, yes, it's attached, but those attachments are fairly superficial. Typically, a tenant would be expected to carry it away if he or she had installed it. Now, suppose we've got a really sophisticated tenant who's able to install central air conditioning. Obviously, that would be deemed a fixture. The tenant would not be allowed to rip all the walls out of the leasehold and remove the central air conditioning that had been installed. And the only remaining issues from landlord-tenant law really are much more to do with remedies than to do with real estate. Both the parties, the landlord and a tenant, have a duty to mitigate damages. They can't just allow damages to keep being racked up and expect the other party to pay for them if the party seeking the damages has the opportunity to reduce those damages. Also, realize that there are special landlord and tenant remedies. In particular, the landlord has got the remedy of evicting a tenant who fails to pay rent. The method of doing so is called an unlawful detainer. We compare that to an ejectment action, which is the plaintiff's theory of liability against a trespasser. And that wraps up a consideration of landlord-tenant law. On the multi-state, this is not very important. Maybe a couple of questions will arise, but this material is heavily tested on the essays, and I think you can see it has almost as much to do with the law of contracts as with the law of real property.